Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. This video centers on a question that's important for every Virginia personal injury case when it comes to being hit by a drunk driver. How does that affect your claim? How does it affect your potential damages, meaning what you can be awarded by juries? And um, how exactly is it that we can, as a plaintiff, get that information before an adjuster to consider your case, but also a jury if we end up going to trial? Now, just as a premise, starting off premise, whenever you're thinking about issues in cases and factual circumstances in cases, insurance adjusters, when we're trying to negotiate settlement prior to filing a suit, when we're trying to communicate to an insurance company what your case is worth, they're going to be having in the back of their mind, what would I be able to convince a judge to allow a jury to hear? There are certain facts that if a court will not permit, usually a good insurance adjuster is going to be aware of that and say to me, James, that's great that you have that fact for you, but we all know that it's not getting in front of a judge. And so I'm not going to consider that. Now, why is that important when we're talking about DUI cases and hit and drunk driver injury cases? Well, the reason being is not every drunk driver case is going to allow me to tell a jury that, hey, my client, my injured party, was hit by a drunk driver. In fact, surprisingly, Virginia law, when it comes to using DUI driving behavior for personal injury plaintiffs' cases, is actually much more narrow than I think most people suspect. Frankly, I'm still a bit surprised by it. But if you look at the law and specifically look at Virginia Code Section 8.01-44.5, I'd urge you to get on Google and pull up that statute. You'll see there that if you read that entire statute, DUI claims in personal injury cases usually only come in two main scenarios. And that's if the individual driver, in addition to other conditions, had a blood alcohol level of a 0.15 or above, or the drunk driver unlawfully refused to take a blood or breath test. There are other narrow circumstances that, without these, that a judge may let a plaintiff tell a jury that the defendant was drunk driving, but that's a very narrow subset. So this video is going to focus on the two main scenarios where DUI information is going to be able to be told to the jury. Now, first of all, why does it matter? Well, the reason it matters is I want to be able to ask the jury to award what we call punitive damages. Now, what are punitive damages? As opposed to compensatory damages, compensatory damages being medical bills, lost wages, pain and suffering, inconvenience, other costs associated with somebody being injured by a drunk driver. Punitive damages is a specific subset of damages where I'm asking a jury to specifically award my client money because that person was driving with such disregard to safety of human life and liberty that the jury should be able to award a specific amount of money to send a message to the defendant driver, the negligent drunk driver, as well as the community that we're not going to put up with drunk driving that's too risky, that if you're going to drive drunk, then you're going to suffer the consequences. So when I'm wanting to present evidence of drunk driving by a defendant driver, the person that injured my client, I'm going to specifically want to be asking for punitive damages. Now, getting back to 8.01-44.5, when can I actually tell a judge or a jury or both that the defendant was drunk driving? Again, it's going to be mostly under two very narrow scenarios. The first is the defendant turns out to have a blood alcohol level of a 0.15 or above. Now, just to be clear, under Virginia law, it's illegal to drink and drive if the drinking itself causes impairment. If you have a 0.08 or above, there's an inference of impairment. So that's what you hear about the legal limit. Now, it's technically, you're technically able to be convicted of drunk driving even if you have below a 0.08, but having a 0.08 or above allows for a judge and a jury to infer that intoxication. Not a presumption, but inference. A 0.15, as you could see, is a pretty high level. It's almost 2 times that base legal limit level. So that's a really high blood alcohol level. And in order to typically get that, somebody is going to be investigated by law enforcement presumably after the accident. They've been investigated for the DUI, and a test was taken by either blood or breath, and that registered back a 0.15 or above. Now, there are other technical issues about whether or not that would ultimately come in, but as a foundation, we need to know that there's above a 0.15 or above in order to go that route for punitive damages. If it turns out the defendant did have that, and there's a certificate of analysis, that's really a foundational point to where your plaintiff's attorney is going to need to know that. Hopefully, if you're being represented by the attorney, you've both discussed that. I imagine that's going to be at the front of your mind. Hopefully, the law enforcement officer was involved in telling you what was going on, keeping you informed. That's not always the case, but hopefully that's happened. And if you end up going after punitive damages, law enforcement will be important in order to help prove that in the civil case. The other alternative is if the defendant, the drunk driver, was required under Virginia law to take a blood or breath test and unreasonably refused to do so, that's got its own separate set of rules as to when somebody's allowed to refuse lawfully a blood alcohol test. But typically, you're going to see a charge of a DUI and unlawful refusal. Now, I do criminal defense as well, and I do a fair amount of drunk driving cases, so I know how it works on the other side as well. But many instances, you'll see situations where there's a refusal as well as a DUI charge. So somebody will be suspected of drunk driving. When they hit you, they're going to be investigated for the drunk driving. Then they're going to unlawfully refuse to take the blood or breath test. And so what would end up happening is law enforcement will charge them with both drunk driving as well as unlawful refusal. And really the reason you see that is the reason the unlawful refusal statute exists is the legislature wants to encourage suspected drunk drivers to take blood and breath tests. That way they can be prosecuted. And so essentially this framework's been set up through the years in order to facilitate that. And so if you end up seeing those charges, that's something that you, again, want to let your attorney know if you haven't already spoken about it. Now, the next question is going to be, well, James, how does the criminal court work in the DUI prosecution? In many scenarios, I see there will be a DUI charge with a refusal. Then they go to court. The refusal is dropped. They'll plead guilty to the DUI. And then people will ask me, well, James, how does that work now? There's no longer a refusal. And because there's no blood alcohol level, there's not a 0.15 or above. But actually, that scenario is still going to be beneficial in the civil case, because if there's a charge of unlawful refusal, presumably law enforcement had a reason to charge them with unlawful refusal, and then a good plaintiff's attorney is going to get in contact with the law enforcement and make sure that they're in a position to try to prove that, like they would in the criminal courts, frankly, call the officer, call the necessary individuals. And there's other statutory frameworks that may be able to make that an easier process. But if you see either a DUI 0.15 or above, or an unlawful refusal charge, or a combination of both, that's where we're going to be really looking at punitive damages as an aspect of your personal injury case. Now, what if, James, none of these apply? What if the person was just being suspected of drunk driving? Maybe he admitted to it, but there was no DUI charge or no unlawful refusal. He or she pled the fifth, and there was no evidence. But it's obvious that they were drunk driving. Maybe they were driving down the wrong side of the road, or some other crazy, dangerous behavior. Now, there is another avenue of trying to get to a punitive damages claim for drunk driving, and it's really the avenue I call the common law avenue. Essentially, you can use other facts in the case to try to establish DUI through essentially that non-statutory framework, the non-8.01-445.5 framework. Now, unfortunately, I will tell you this scenario is a very difficult route to go. You would think that it would be pretty easy if, let's say, the defendant came up to you afterwards and smelled like alcohol, was obviously intoxicated, but that DUI blood alcohol level wasn't discovered, and there was no unlawful refusal charge. But honestly, the case law is pretty bad. Virginia is one of the very difficult states for plaintiffs' attorneys. And individual victims of drunk driving offenses when it comes to the plaintiff's side. And so the case law has really made it difficult. I've seen cases litigated where the person was driving down the wrong side of the road. That alone wasn't enough. Before the accident, a friend or family told them not to drive. That alone wasn't enough. So if you don't have the route of the above 0.15 or unlawful refusal, that doesn't mean don't tell your attorney about it, don't have a discussion. If a client comes to me with this scenario, I'm going to do my best to research it to see if I can't shoehorn in a punitive damages claim. And even if it may not get to a jury, I'm still going to make sure that I talk to it with an adjuster when I'm trying to settle the claim, or the defense attorney. Just the threat of potential punitive damage claim there, I'm going to try to use. But I just want to give everybody a heads up that there may be an issue in those scenarios where it's not an avenue previously discussed. So I know this was a bit longer of a video than you anticipated, but hopefully it answers a lot of questions. If you have any other questions, make sure to reach out to us, www.abreniolaw.com. Thanks a lot, and I wish you the best.